Okay, so that's our focus tonight, the shocking case of a Toronto pathologist whose testimony sent a number of people to prison. How did it happen? What safeguards should be in place to make sure it never happens again? Joining me tonight to talk about this, to take your calls, criminal defense lawyer Joe Neuberger, and welcome back to Legal Briefs, Joe.
Thank you.
Let's set the plate here, because this is not the Charles Smith inquiry, and I think people have to understand that. This is not an inquiry to find criminal or civil liability. This was an inquiry to conduct a systemic review of the practice of pediatric pathology, forensic pathology from 1981 to now. And all that's happened here is the Charles Smith cases, and he admits that he made mistakes, and nobody's going to take anything away from the effect that it had on the families. But it is pointing to a lot of things in that system. That's exactly what this inquiry is looking at, that were at fault. And I think we got to remember that.
Yeah, that's fair.
And when you look at this and you see it, I mean, there's so many issues to talk about. The issue of the expert witness and what that's like for somebody who is given that title. Today, Dr. Smith said that his training was woefully inadequate. And yet, when this man walked into court, and anybody who is an expert, a jury looks at them almost like they're gods.
Absolutely. What the public has to understand, and the judicial system has to understand, is that when an expert witness like that hits the stand, their opinion is so close to what we call the ultimate issue, guilt or innocence, that it is incredibly powerful. And it can sway a jury or a judge very easily, because a trier of fact, a judge or a jury, will look at it and say, well, the person's qualified as an expert. As a result of that, they come with all of that experience and training, and their opinion carries the day. Exactly.
And it's interesting. This is what he's asked with respect to that training, to become this expert in forensic pathology. And he was considered by staff, by everyone in the coroner's office, etc. He says this. He's asked, how would you describe your training in forensic pediatric pathology? And he said it was self-taught, it was minimal, and retrospectively, it was hopefully inadequate. And that is very scary. And that's what people should understand when you're looking at this case, to look beyond Dr. Smith and look beyond what was happening in the system.
The difficulty, though, is, and I accept that, and that means there is some flaw in the system, and hopefully when we're talking about 2000 and onward, the training for these experts is much better and enhanced. The difficulty is when he took the stand, he didn't have the humility of somebody who had training that was inadequate. He spoke directly on the issue with such assertion as an expert, almost to say to the jury or the judge, this person is guilty of murder.
And
that's the difficulty.
And that's the thing that can never be taken back.
It can't. And today when he says, I did not appreciate my role as an expert, that is incredible. He understood exactly what his position is as an expert when he hits the stand. If not in his first year or his second year or his third year or his fourth year, certainly halfway through his career he understood that. And he was not daunted by the fact that he did not have adequate training or he did not have the peer review of his work.
And yet that's a retrospective look, correct? Because so much of this is a